EPA grants 63 small refinery exemptions. The Environmental Protection Agency, EPA, has completed its long-delayed adjudication of 175 petitions for small refinery exemptions, SREs, under the Renewable Fuel Standard, RFS, covering compliance years 2016 through 2024. The August 22nd decision provides long-awaited clarity to refiners, renewable fuel producers, and credit markets after years of litigation and shifting interpretations of disproportionate economic hardship. EPA granted 63 petitions in full, 77 in part, denied 28, and found 7 ineligible, affecting roughly 5.34 billion renewable identification numbers, RINs, across nearly a decade of compliance years. Returning previously retired RINs is the least disruptive and most equitable way to implement exemptions for past compliance years, said Aaron Szabo, EPA Assistant Administrator for Air and Radiation, in the August 2025 Federal Register notice. What the decision covers: petitions reviewed 175 from 38 refineries nationwide. Compliance years 2016 to 2024. EPA has not yet ruled on 2025 petitions. Outcome: 63 full exemptions, 77 partial, 50%, 28 denials, 7 ineligible. Approximately 5.34 billion RINs, about 1.39 billion, remain usable because of the 2-year RIN credit life. The agency emphasized that billions of credits are involved, but the impact on current and future compliance years will be limited. EPA anticipates little effect on 2024 and beyond because most of the affected RINs have already expired. How EPA will implement the decision. One of the most closely watched aspects of the decision is EPA's implementation method. Many small refineries had already submitted compliance reports and retired RINs for the years in question. To resolve this, EPA said it will return previously retired RINs rather than mint new ones. This approach, EPA argued, is the only statutory and market-consistent option. Issuing new, current-year RINs would have injected roughly 3 billion additional credits into the market, potentially destabilizing RIN prices and discouraging renewable fuel investment. The return approach means full exemptions, all RINs retired for that compliance year are returned. Partial exemptions, half of the retired RINs are returned. Expired RINs may have little compliance use but retain residual value to the refinery. Unexpired RNs, e.g. 2023 vintage, can be applied toward open 2024 obligations or traded before the December 1, 2025 deadline. Legal authority and nationwide scope. EPA's decision rests on 3 determinations of nationwide scope and effect, making the D.C. Circuit the venue for any judicial review. EPA has the authority under the Clean Air Act to grant partial exemptions. The DOE's 2011 Small Refinery Study Matrix is a reasonable proxy for assessing hardship, and EPA will defer to it unless other economic factors compel a different result. Returning RINs, rather than creating new ones, is the only lawful and market-stable implementation method. This framing follows the Supreme Court's June 2025 Calumet decision, which clarified Clean Air Act venue rules, and the D.C. Circuit's Sinclair 4 ruling, which found EPA's earlier blanket denials arbitrary for failing to consider other economic factors. Why it matters for industry, for refiners. The decision provides relief to smaller facilities that demonstrated hardship and reaffirms that refineries do not need to prove the RFS was the sole cause of hardship, only that compliance contributed significantly. For renewable fuel producers, the ruling reassures markets that EPA will not dilute RIN values by issuing fresh credits. By opting for returns of previously retired RINs, EPA avoided a potential flood of 3 billion new credits. For credit traders, because about 1.39 billion of the impacted credits remain valid, traders will need to adjust positions, but the bulk of returned credits are expired, limiting near-term disruption. Industry reactions. Biofuels sector. The Renewable Fuels Association, RFA, called the decision to clear the backlog and rely on RIN returns reasonable, but stressed that reallocation of waived volumes remains critical to preserving renewable fuel demand. Refining sector. The American Fuel and Petrochemical Manufacturers, AFPM, reiterated its concerns over future RFS compliance costs, warning that obligations for 2026-2027 could impose up to $70 billion annually in burdens on refiners and consumers. Environmental perspective. From an environmental standpoint, EPA's August 2025 SRE decisions raise concerns about lost renewable fuel blending and associated emissions reductions. While the agency emphasized that returning retired RINs avoids market disruption, exemptions still translate to fewer gallons of ethanol, biodiesel, and renewable diesel entering the U.S. fuel supply. The 5.34 billion RINs affected represent billions of gallons of renewable fuels that will not displace petroleum, resulting in higher cumulative greenhouse gas emissions over time. Advocates for biofuels argue that frequent exemptions weaken investment certainty and undercut the RFS's core purpose of reducing transportation sector emissions. Transportation remains the largest source of U.S. greenhouse gases, and environmental groups warn that carving out compliance relief for small refiners slows national progress toward climate targets. Even with EPA's decision to avoid flooding the market with new RINs, the underlying exemptions mean foregone decarbonization benefits that could have advanced U.S. clean energy and emissions goals. Next steps and regulatory implications. EPA will submit a supplemental proposed rule on reallocation of exempted 2023 plus volumes. Clarify how future SREs will be projected into the 2026 to 2027 Set 2 standards. Both issues will shape the compliance market and renewable fuel blending targets for years ahead. Broader policy context. The decision highlights the balance EPA must strike between supporting renewable fuels and considering disproportionate burdens on small refineries. Since the Renewable Fuel Standard's creation in 2005, SREs have been a flashpoint in the biofuels versus refining debate. EPA's reaffirmation of partial waivers signals a compromise, acknowledging hardship without granting blanket exemptions that reduce overall renewable blending. For policymakers and stakeholders, the ruling underscores the continuing evolution of RFS administration amid court rulings, congressional direction, and market realities. You've been listening to Sustainability Soundbites from E+E Leader. Are you in the market for expanding your company's reach? Contact us today to learn more about custom sponsorship opportunities available for your industry.